Hi, welcome to my court coach. This is Jaylyn and I'm going to be your instructor. Today's segment is going to be about the Hague Convention, and the Hague Convention specifically relates to child abduction cases. If the court has made a child abduction order, then you can now take this to the Hague Convention and have them access or return your child. When I say access, I mean locate your child. So the court, if they had filled out this form, the FL 341B, and if you're not familiar with it already, please watch our other videos explaining the usage and purpose of the FL 341B form, which is the Child Abduction Prevention Order Attachment. Now, the court order says right here that this is valid in other states and in any country that has signed the Hague Convention on Child Abduction. In fact, it notices other authorities in other states and countries. This court has jurisdiction to make child custody orders under the California Uniform Child Custody Jurisdiction Enforcement Act and the Hague Convention on Civil Aspects of International Child Abduction under 42 U.S.C. Section 11601. If jurisdiction is based on other factors, they're listed above in item 13. And so if the court does make any orders with respect to its authority in ordering this child abduction order or having authority over the child, then the court will list those orders right there. So now you have this 341B of order, and you need to get your child, and you're going to go through the Hague Convention. And the reason why you're going through the Hague Convention is because your child is not within the United States of America, okay? So if your child is within the United States of America, you would not use the Hague Convention. So this distinction is very important because, again, you would not go through the Hague Convention if your child is within the United States of America and you are aware that your child is somewhere in the United States of America, or you know what state that they are in, or they are with the other party, or a grandparent, or whatever it might be. There's a whole different process and procedure for that, but this is relating to child abduction in a different country. So let's go to this 42 U.S.C. 11601. It states that the Congress makes the following findings. The international abduction or wrongful retention of children is harmful to their well-being. Persons should not be permitted to obtain custody of children by virtue of their wrongful removal or retention. International abductions and retentions of children are increasing, and only concerted cooperation pursuant to an international agreement can effectually combat this problem. The Convention on the Civil Aspects of International Abduction, done at The Hague on October 25, 1980, establishes legal rights and procedures for the prompt return of children who have been wrongfully removed or retained, as well as for securing the exercise of visitation rights. Children who are wrongfully removed or retained within the meaning of the Convention are to be promptly returned unless one of the narrow exceptions set forth in the Convention applies. The Convention provides a sound treaty framework to help resolve the problem of international abduction and retention of children and will deter such wrongful removals and retentions. The Congress makes the following declarations. It is the purpose of this chapter to establish procedures for the implementation of the Convention in the United States. The provisions of this chapter are in addition to and not in lieu of the provisions of the Convention. In enacting this chapter, the Congress recognizes the international character of the Convention and the need of uniform international interpretation of the Convention. So, with that being said, we are going to see what countries are part of the Hague Convention. Because now we know the purpose of it, and it's to return or locate the children in a different country. You already have a child abduction order. And now we need to make sure that the country that we're trying to get our child from is part of the Hague Convention. If they are not part of the Hague Convention, if the country is not part of the Hague Convention, then it is going to be exceptionally difficult for you to obtain your child, especially if you do not know the whereabouts of the child, but you would need to take international family law procedures in that country to figure out how you can obtain your child. If you did know that they were in Dubai, for example, then you would go to that country and figure out how to enforce your California orders or open a brand new case. But for today's segment, let's focus on the Hague Convention. So we're going to just pick a random country, and Australia. So if we wanted to get a child from Austria, actually, we're going to go to this website. It's travel.states.gov, and it's a great website to find out whether you're even eligible to file the Hague application, meaning whether the country is in fact part of the Hague Convention, and whether they can actually process your application based off of the child's age. Now, if the child is over the age of 16, then the Hague Convention would not apply. They would not be able to help you. You would need to find some other measures, and those other measures is as if, the Hague Convention is not part of, the Hague Convention would not apply, and therefore you would need to take other measures like going to that country and starting a family law proceeding there. You would need to just check with that local laws of that country to figure out what to do. So we're going to pick Austria like we did before and say, is your child under the age of 16? The answer will be yes, because the convention only applies to children 15 and younger. So we're going to say display. All right, so it tells you that you are eligible to file the Hague application, and you're going to be able to file it because it is a Hague Convention partner, and your child's under the age of 16. Now, to determine whether the U.S. Central Authority will accept your application, you have to contact your country officer to discuss your case. And you can use one of these two numbers to contact the country officer. However, it also tells you, note, to file a application, you must have had a custodial rights and been exercising those rights at the time of the abduction or wrongful retention, or show that you would have been exercising those rights if the abduction or retention had not occurred. Custody rights may be awarded by a court order or arise of operation of law of the place where the child lived prior to the abduction. Have not been given permission for the child to be removed, or in the case of wrongful retention, to be retained beyond a specified period, agreed upon period of time, or be able to show that your child was habitually resident in the country to which you are requesting the child to be returned. So, in summary, you can't ask the other party to keep the child for like an additional week, and then all of a sudden you're filing in the Hague Convention asking that the child is returned, even though you provided your consent, your agreement that the child can stay an additional week with the other parent or an additional month with the other parent. So it's really for the purposes of parents that do not know that where their child are or where their children are, or the other parent is refusing to return your child. And so you do have to prove your custodial rights, and if you have a child abduction order, it is going to list out your child your child custody rights, and then be able to show that your child was habitually resident in the country to which you requested the child be returned. And again, that will be part of your child abduction order. So we are going to file with the Hague Convention, and before you file, we need to get these documents in line first. So a marriage certificate, if you were married to the parent of that child, You need to provide the birth certificate for each child, and then the divorce decree or judgment if you were divorced from the parent of that child. And they need to be certified copies as well. So you need to make sure that there is the seal on there from the court to show that it is a certified copy. And then you need to show the evidence of custodial rights, so the custody order, and then other relevant court documents. So if you have documents beyond the child abduction order, for example, if you have multiple documents asking that the other parent return the child and they haven't, I think that's going to help build your case and allow you to qualify for the Hague Convention. And then photographs taken of you and the child. Please note that these will not be returned. Also, photographs of the child and the other parent or the other party that took the child. Statement regarding the circumstances of removal or detention. So how was the child removed? How did you get to this point? And a lot of that actually will be in your declaration when you ask for the child abduction order. So you should just provide that. Other documents that's specifically required by the receiving country. So you would need to look at Austria, since that's the example that we're using, and whether they require other documents. And then translations of the above documents into the language of the receiving country. So if Austria didn't speak English, then you would be doing it in their foreign language, but they do. And then application for legal assistance if you need it. So what does this form look like? So this application under the Hague Convention on the Civil Aspects of International Child Abduction, is going to be an application for either returning the child or accessing the child, meaning locating the child, because you don't know where the child is exactly. So you're going to write the name of the child, the date of birth, their place of birth, their habitual residence, so at the time of removal, so it should be yours, the US SSN number, the social security number, their passport information, their current location if you do know it, the telephone number of the current location if you do know it, whether they're US citizens or other citizens of different countries, their height, their weight, their color of hair, color of eyes, name of the child's father if it's not already listed below, and the name of the child's mother if it's also not already listed below. So the person that is completing the application must complete their last name, their date of birth, the place of birth, the relationship to the children, so a mother, father, or legal guardian, the citizenship of that parent, and their social security number, their passport information, their current address or telephone number, email address, their language, preferred language, what occupation do they have, and then name and address, telephone number of their attorney if they do have one. And then person alleged to have wrongfully removed or retained the children or child. So it's the other parent or the other party. So their name, their date of birth, their place of birth, their relationship, their citizenship, their social security number, their identification on their passport, their occupation, their other known names that they go by, addresses and telephone of their current location if you know it, the height, weight, their color of hair, and their color of eyes. And then if there's additional children, you're going to complete the same exact information that you completed above, but specific to that particular child. And then the circumstances of wrongful removal or retention. So you're going to need to include the date, so the use appropriate date if exact date is unknown. So whether it's April 4th of 2018, and then the place of wrongful removal. You could say, somewhere in California. I guess you could say like Sacramento, California, USA. And then the circumstances of the abduction, and you can attach additional sheets. So you can give maybe a brief summary here, and then include like see declaration attached and incorporated here too. And you could also just attach it to this form as well. And that would help. There might be several dates of the wrongful removal because there's a history of this with the other party, and now it's just happened, to the extreme. So if that is, the case, then your declaration should really specify that, or at least specify it here. And if you have different declarations for that, then you can just write maybe the date and then what it is exactly that happened that led to that circumstance. And then factual and legal justification for the request of the habitual residence of the child. So it should be the United States. And then provide any details relating to the place of habitual residence. So any details that you have in regard to that specifically, you can go ahead and provide that. But you should really just provide your address. And the legal justification is that you do have a court order, and the court has already made that the state of California or the country of the United States of America is the country of this child's habitual residence. So you will have that along with your child abduction orders. And then basis of your custodial rights. So you do need to provide the documentation of that and make sure that your documentation does state that you do in fact have child custody rights. And if it doesn't state that, then you obviously wouldn't be able to get to this far of getting a child abduction order. So you do have to have custody rights in order for you to, in fact, file this form. So supporting documentation can be, laws relating to the custody for the child's residence or time of alleged removal or retention, a court order in effect at the time of the alleged removal or retention, or a legally binding agreement between you and the other party. Or any other forms or documents that would assist them to know what kind of custody rights that you do have. And then, are there any civil proceedings currently in progress? And if the answer is yes, then you are going to go ahead and provide those details. And then proposed arrangement for return of child or children. So how will the children return? So are they going to return via flight, boat, whatever you can, think of? How will the children be, in fact, returned to you? And then will you or someone will be designated as a power of attorney to accompany the child? Please provide as many details as possible. And then as part of your child abduction order, as we discussed in a different video, that you could have a bond on there too, so that the other party does in fact reimburse you for any costs related, to trying getting your child back because they were abducted. So you want to provide as much detail as possible as to how you're going to arrange for the child to travel and come back to you. And then other persons with additional information relating to the whereabouts of the children. So preferably in country of child's current location. Please include the name, relationship to the child, address, and contact information. So if the children were, again, taken to Australia, and you know that the other party that took the child has grandparents there, then you can list their information, their last known information, their full name, anything you know about them that would help the Hague Convention to return or access or locate your child. And then any other supporting documentation or relevant information. So whether the parties were married, if so, then what date were they married, were they divorced, then what date were they divorced, and you do have to, in fact, provide your divorce decree. And when it says parties or parents married, that means currently. So, because obviously you needed to get married to get divorced, and so if you're currently married to them, then you would say yes. If you are not currently married to them, you'd say no. And if you're divorced from them currently, then you would provide the answer yes, and then you would provide the divorce decree. And remember, it has to be certified, so you need to get that from the court. And then the custody order existing at time of removal or retention. So you should literally just copy the custody order that was made prior to the child abduction order. So hopefully it's specific, because if it's something general like as reasonably agreed between the parties, then that's not going to be specific enough, and then you're going to need to provide maybe text messages, your emails, or whatever contact that you've had, and hopefully those are also in writing between you and the other party to show that there was an agreement pursuant to the court order, which is reasonable visitation is mutually agreed upon between the parties. So you need to provide as much information as possible, and you should, of course, provide that court order that states that. You're going to go ahead and sign it, and you're going to go ahead and date it, and it says that it must be signed in blue ink. So if you don't have a blue ink right now, then go and buy one so you can complete this form properly. And then the Privacy Act statement. So the information solicited on this form is requested under the authority of the International Child Abduction Remedies Act. The primary purposes of soliciting the information is to evaluate the applicant's claim under the Hague Convention on the civil aspects of international child abduction, inform applicants about available legal remedies, and locate the abducted child. Furnishing your social security number as well as the other person's information that's requested is voluntary. The social security number may be used if necessary to authenticate the identities of the individuals that are listed in the applicant's claim and their routine uses. This information will be used to assist in facilitating operations under the convention and may be provided to governments of member countries, bar associations, legal aid services, local police, social service agencies, attorneys, parents. The information may be released or on a need-to-know basis to other government agencies, including foreign agencies having statutory or lawful authority to gain access to such information. More information on the routine uses for the system can be found in the System of Records Notice, Overseas Citizen Service Records, and the Department of Prefatory Statement of Routine Uses. Then the disclosure states that providing this information in this form, including the child's social security number, is also voluntary. Failure to submit this form to provide all the requested information may result in delay in the processing of your application. And then paperwork reduction statement. Public reporting burden of this collection information is estimated to average 60 minutes per response, including time required for searching existing data resources, gathering the necessary data, providing the information required, and reviewing the final collection. You do not have to provide this information requested if there is approval, if the approval has expired. Send comments on the accuracy of the estimate of burden and recommendations by reducing it to this address. And really, that is probably not going to be relevant to you. So now you've completed this form, you've gathered all of the documents, and you are ready to file this form with the Hague Convention. So you need to submit the application to the country officer. So you could, contact the country officer to make sure that your application is complete and just have a conversation with them about what the documents that you're attaching to your application. I think that would be very helpful for you to do. And then after you've gotten essentially the green lights to go ahead and complete or to submit the application, then you are going to send it to the U.S. Central Authority with mail tracking option, and it's going to be the U.S. Department of State, Bureau of Consular Affairs, Office of Children Issues, CA/OCS /CI SA 1794, Washington, D.C. 2522-1709. If you have access to email, please scan and email your application to your country officer. Be sure to sign and date your application form. The country officer assigned to your child's case will review your application to ensure that it is complete before forwarding it to the central authority, which is why it's really good for you to call the country officer and go over your form with them. And after you do all of that, what's the next step? How long does it take? So it says stay in frequent contact with your country officer responsible for cases involving the country where your child is located. Let the office know if your contact information changes so that they may reach you as your application is processed. If there is any information that changes, contact them. Once the U.S. Central Authority receives the Hague application, determines that it is complete and meets the requirements for acceptance, it will be transmitted to the Foreign Central Authority. That Foreign Central Authority is responsible for processing your application. Operations and procedures vary by country. Your country officer who's experienced with procedures in the country where your child is located is available to help you understand the process and will provide updates for you as your child's case progresses through the foreign legal system. However, keep in mind that a country officer could not provide you with legal advice. It is best to speak with an attorney before taking any action on your child's case. When a taking parent learns that a Hague application has been or will be filed, he or she may just return the child voluntarily to avoid further civil action under the convention. The taking parent may also be open to mediation. Many Hague cases do go to trial. Some countries may require that you retain an attorney in the country where your child is located. In other countries, the foreign central authority is responsible for filing the case in court and may not be able to do so if you retain a private attorney in that country. However, if the foreign central country files the case in court, it may only represent the Hague Convention, and therefore the foreign attorney in the role of the central authority. Please contact the country officer assigned to your child's case. Please note that the country officer and the U.S. government officials, including the embassy employees, are not able to act as an agent or an attorney in legal proceedings. If the taking parent does not voluntarily agree to return your child, you may want to attend a legal proceeding in the foreign court about your application for return. For this reason, it's a good idea to make sure that you have a valid passport and visa if necessary during this process, so that you're able to quickly travel to the foreign country if it becomes necessary. We hope that you have found this video helpful, and best of luck.